Let's say you entered the US in 2000 and you had a final deportation hearing in 2001, you didn't show up, and you get a removal order. This is referred to as an in-absentia removal order, where you are ordered deported in your absence. Today's video is gonna be a little bit more technical. I'm gonna be explaining how to fix an old removal order. And I have a lot of clients who I've seen who have like 20 or 30-year-old removal orders. They've never had any criminal history. They entered the US a long time ago and they just, didn't show up to court, or they showed up to court and the judge denied their case and they never departed the United States. And a lot of these people have US citizen children who are now over the age of 21. Some of them even have grandchildren, and they just became disillusioned by the immigration process and don't think there's any way to fix that old removal order. One of the things that I do is I try to reopen those old removal cases to fix the deportation order. And so I'm gonna take a overview position for a minute to just explain what you need to do, and then I'm gonna get a little bit more detailed and technical. So when you have a deportation order or a removal order, you have to reopen those old removal proceedings. The moment that your case is reopened, there is no more removal order, but you are now in deportation proceedings again, and you need to fix that. So you'll go from having a closed case with an active deportation order to a reopened case that's now pending, and there will be a future hearing date scheduled. And you still need to defend yourself. So if you don't have a clear pathway to permanent residence, I wouldn't even try to reopen these old removal orders. In most cases, it's fact specific. I don't just want to say that as a blanket statement. So talk to an attorney if you have an old removal order. Don't just listen to an attorney on YouTube. These are general facts. It's not case specific, so your case might differ. Okay, so there are two main ways to reopen an old removal order. By the way, there are actually more than two ways, but there are two main ways that I use all the time. One of them is if you never received notice of your old hearing. So for example, let's say you entered the US in 2000 and you had a final deportation hearing in 2001, you didn't show up, and you get a removal order. This is referred to as an in-absentia removal order, where you are ordered deported in your absence. If you knew about the hearing and you just decided not to show up, then this strategy isn't gonna work for you. But oftentimes I talk to people and they say, we never received the notice. I was waiting, I updated my address with the court, and I just never got the notice. I don't know what happened. It might have gotten lost in the mail. I was living in a house with a lot of other people. Maybe someone took it, maybe it got lost, but I never received notice of that hearing. If you actually never received notice of that hearing, we probably have a clear pathway to reopen your old removal proceedings. And what we would need to do is submit a motion to reopen the in absentia removal order directly to the immigration judge. And the judge would need to believe that you never received that old hearing. I like to do a Freedom of Information Act request first to try to get a copy of any documents in your alien file, because sometimes right there it lists an incorrect address, or there's some other indication that you never received it. For example, if you updated your address with the court and they sent your hearing notice to your old address, that would also be a clear basis. Sometimes the Freedom of Information Act request doesn't really say anything helpful. In addition to whatever records we can find in your immigration file, I like to prepare a detailed affidavit from you, the client, explaining exactly what happened and that you never received the hearing notice. I've been pretty successful with these, but it depends on the judge and whether or not they believe that you actually didn't receive the notice. And by the way, I've recently reopened old removal orders from 20 plus years ago. So the amount of time that passes isn't particularly relevant in this case. When you reopen the removal order, you now need to defend yourself. If you don't have a clear defense, then you're just gonna get a fresh removal order 20 years later. And that's probably even worse, because now you're probably an enforcement priority. Your removal order is gonna be placed on enforcement and removal operations ICE office desk, and now they have like a fresh removal order that they need to enforce. So that would be a worst case situation. What I like to do is make sure that you're eligible for a green card. So let me give you an example. I have a guy who entered like 25 years ago. He didn't receive the notice for the hearing, and he has a US citizen son who's over age 21. My client, the guy with the removal order, previously had TPS, temporary protected status. And when he had TPS, he applied for advanced parole, which allowed him to travel internationally and re-enter with a lawful inspection. So he entered with inspection, he has a legal entry. If you have a legal entry and an immediate relative, then you probably are eligible for permanent residence. And in this case, he does have an immediate relative. He has a 21-year-old US citizen son or daughter who can petition for him. So he's eligible for permanent residence. The only problem is the old removal order. So we did a Freedom of Information Act request because the client told me he never received notice of that old hearing, and he wasn't even sure that he had a removal order until I looked his A number up in the EOIR court system. So we did a Freedom of Information Act request, and it turns out that they mailed the old hearing notice to a literal non-existent address. They completely botched the address and they sent it to an address that literally doesn't exist. Didn't exist back then, doesn't exist today. So I included that old hearing notice with the address and evidence suggesting that that address doesn't exist, and a statement from the client also stating that he never received the notice. The judge reopened the case. We showed that he's clearly eligible for permanent residence. They terminated removal proceedings, and now we're applying for permanent residence with USCIS, because when you have an old removal order, USCIS cannot adjudicate. They don't have the power or jurisdiction to make a decision on your I-485 green card application. So that's the general procedure if you qualify for permanent residence and you received an in absentia removal order where you didn't know about the hearing. If you did know about the hearing, or we cannot make these in absentia removal order arguments, there is another way we can reopen the removal order, but it requires the consent of the Department of Homeland Security Office of Chief Counsel. These are the deportation attorney office. And these are the people who try to get a deportation order during your removal hearings. So what we need to do is submit a request for them to join our motion to reopen your removal proceedings, because there are only a couple ways that judges have the power to reopen removal proceedings. One of them is if it's in absentia, the judge can just make a decision on that. Another way is if there are exceptional circumstances, the judge can just make a decision on that without the Department of Homeland Security giving their consent. But if none of those situations apply generally, and enough time has passed, generally speaking, the only way to reopen these removal orders is with a joint motion to reopen. So the Department of Homeland Security and the respondent, which is the immigrant who was being deported, their attorney, have to jointly request that the judge reopen. If both parties agree to reopen, the judge will reopen the old removal proceedings. However, the big problem with this right now is that since Trump took office, the Department of Homeland Security just has a blanket policy where they're not entertaining requests for favorable discretion. So I'm under the impression right now that we're not going to be able to request the Department of Homeland Security join our motion to reopen until the Trump administration changes that policy, or more likely Trump is no longer in office. And even then, it depends on what his successor does. Historically, Republicans and Democratic presidents have had priorities for removal. And, Trump did away with all that. Pretty much everyone's a priority now, whether you're a criminal or you've been here for 30 years and you contribute in a major way to society. You are both equal priority for removal as far as the Department of Homeland Security is concerned. So we cannot do joint motions to reopen right now, but in a couple years, hopefully we will be able to begin doing this again. You might be a good candidate for a joint motion to reopen if you qualify for permanent residence, and the only problem is that old removal order. If you've been contributing to society, you're a person of good character, no criminal history, these are good candidates for joint motions to reopen. We would submit all the evidence of your character to the Department of Homeland Security, maybe some old tax returns, proof you have family and ties, a good job, or a stable job and you're contributing to society. And evidence that you're eligible for permanent residence, and the only reason you can't get permanent residence is because of this old removal order. Generally, if you meet all of these conditions and the Department of Homeland Security is accepting and considering joint motions to reopen, you probably have a good chance of getting them to agree. And then they'll give you their consent, and you can include that consent with the motion that you prepare and submit to the immigration judge. All right, guys, if you've made it this far in the video, you're probably the select few who really care about the nitty-gritty of immigration law. If you want to learn more about immigration law directly from an immigration attorney's perspective, be sure to subscribe to the channel. If you yourself need any assistance with a family-based immigration matter, naturalization, or removal defense situation, or you just want to get some advice or run some ideas by an immigration attorney, be sure to schedule a consultation directly with me. You can find my scheduling information in the video description below. It takes like 5 minutes to book a consultation, and I'll see you guys next time for another video.